Go.
All right. I'll let you know when we're being live streamed. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for this hearing, as well as the other 5 cases that we will hear in the Hale courtroom a little bit later on this morning, are Justices Amy Blake and Vicki Henry. The first case we are hearing on by virtue of Zoom to accommodate some scheduling needs of the participants. The case is case number 2022 P1164, CARRIE DEANGELO versus the town of Truro and others. Ms. Beauregard-Rome, you may begin.
Thank you, Your Honor. Good morning, Your Honors. Good morning, Mr. Clerk. My name is Adrienne Beauregard-Rome. I represent the appellant, CARRIE DEANGELO. As the court is aware from the briefings, Ms. DEANGELO has brought claims for gender and sexual orientation discrimination against the town of Truro and 2 of its employees. Ms. DEANGELO, as the court is aware from the briefings, was the only female in her department for the majority of her tenure with the department until another female was hired as an officer, and she was a probationary officer when Ms. DEANGELO was constructively terminated in October of 2016.
Could I ask you, counsel, if we could get right into sort of the arguments? I'm wondering if you could help me with the continuing violation doctrine. When do you say the clock started to run, if you will?
So I don't think that the parties are in disagreement, Your Honor, as to the 300 days, which is on or after July 28th of 2016. There are numerous instances of discrimination after that day, which the appellant has argued the lower court erred in dismissing her claims because her constructive discharge anchored that the prior claim, the prior incidents of harassment. The incidents of harassment that
Could you give us some examples?
Absolutely, Your Honor. For example, in the record before the court, Ms. DEANGELO testified at her deposition that she was seeking medical treatment for she described it as being diagnosed as with an adjustment disorder as of August and September of 2016. That is after the 300 days.
It seems to me that that is impact, but not actions. What are the actions of discrimination that occurred after the 28th of July?
So, Your Honor, it's my understanding, though, under Salve versus Suffolk County Sheriff's Department 67 Mass Act Court 596, that the ongoing harassment causing deterioration of mental health can be one of the events of discrimination that can anchor the prior claims. That's my understanding, Your Honor, from the case.
But what's the harassment?
The harassment. So, Your Honor, the problem with I believe that the defendants hung their hats on a one-line sentence of Ms. DEANGELO at her deposition when she was asked by opposing counsel whether there was specific harassment as of this certain date, and she said no. And I would argue to the court that a police officer certainly isn't versed in knowing what harassment necessarily is.
I understand, but the question is, you've included in your brief a broad statement suggesting that there were acts of harassment after the 28th, but I don't see any record citations pinpointing what they were or when they occurred.
Your Honor, there was evidence before the lower court that the union vote and Mr. Bayer's active campaigning against Ms. DEANGELO to receive the Sousa report, that occurred in September of 2016. That is an act of harassment. It's a continuation of Mr. Bayer's pointed campaign against Ms. DEANGELO because of her gender and her sexual orientation. I also have argued to the court, and this is a matter of first impression from what I understand.
So you're saying that this underling officer Bayer campaigned against DEANGELO receiving the Sousa report?
Yes, he did. He was the president of the union.
Okay.
I've also argued before the court that given the Meehan case by the SJC 488 Mass 730, which underscored and uniquely gave the a specific cause of action for retaliation for violations of the personnel record statute, I believe that that has opened the door and should allow a plaintiff in a discrimination suit to be able to say that any violations of the personnel record statute should also constitute harassment that is actionable under 151B. And that was a pointed effort or pointed by the town. They refused in June to give her a copy of the report. She made a FOIA request in June, on June 13th, they refused to produce.
So let me pause you, counsel. So if the town was required to give her the document and put it in her personnel file and did not, you're saying that that by itself has the town can be liable. Is that correct?
I believe so, Your Honor. After reading the Meehan case and also the Charles versus Leo case, the two cases that have come out that really have underscored how important it is for the personnel record statute to be complied with.
Well, those may be violations and may be separately actionable, but I guess I'm questioning how they anchor a claim for discrimination in the absence of evidence in the record that illustrates that the refusal to turn over the report was itself based on a discriminatory purpose.
Well, Your Honor, Ms. DeAngelo has maintained from the outset that the constructive discharge itself was certainly sufficient. And if you look at the totality of in the timeline here, and the defendants have argued in their briefs that Ms. DeAngelo should have known. And it's very clear from the record, Ms. DeAngelo continued trying to fight to be treated properly through September of 2016, when she finally was able to get her union to vote in seeking this personnel record that would exonerate her from the alleged misdoings that she was, severely punished for, that Mr. Souza clearly in his report said she did nothing wrong. She was fighting for her position and to maintain her position within the department and be exonerated through September of 2016. And then as of October 2016, that is when she resigned. And I do believe that that timeline there shows that she really believed that she would be able to right the wrong in this situation.
If I understand things correctly, at some point she received a copy of the report, not from the town, but from Mr. Souza himself, right?
No, that's not right, Your Honor. It's actually not obtained until they even fought it through when Ms. DeAngelo, and this would, have to be me testifying, I suppose, but Ms. DeAngelo at the MCAD proceedings, they still fought to produce it. It wasn't until Ms. DeAngelo filed in Superior Court and we got into discovery that they finally produced it pursuant to a RFP.
That's when the town produced it, but maybe my question wasn't clear. I thought I read somewhere that she obtained a copy of it from the author of the report.
She did not, Your Honor. The author of the report, Mr. Souza, had told her, which is why she was so interested in looking at the report and obtaining a copy of it. He had told her that he had written a report where he outlined that he thought that she had done nothing wrong and that he himself thought that she was being subject to discrimination, insubordination, etc., by her subordinates. But he wasn't able to give her a copy of the report.
So the town, I believe, is going to argue that this Bayer was just a jerk to everybody and he was just subordinate to everybody. So what's your response to that?
Even if he was a jerk to everybody, Your Honor, first off, that wasn't his testimony during his deposition. He certainly never indicated that he had ongoing problems with everyone. And if he was a jerk to everyone and was such a bad employee, then why wasn't he disciplined? Why wasn't
that is quite a question, yeah.
Why was it that after this discovery of the relationship between Officer Valley and Mr. Bayer, he was able to resign his position, continue with benefits, etc., and the female officer that was involved in this relationship was given a suspension?
So
That's-
but again, timing, when was he allowed to resign?
It was after Ms. D'Angelo's departure.
How,
But it-
how long after?
Your Honor, I would have to be, a reasonable estimate would be about 1.5 to 2 years after Ms. D'Angelo left. There is case law that I cited in the lower court. I did provide, and the court has before it, an affidavit in the evidentiary record from another female employee with the department who attested to how the town had a culture of accepting negative and demeaning discriminatory comments about women. There is case law that says that that kind of evidence can come in terms of the culture of an employer. And I would argue that this disparate treatment between Bayer and Valley, even though it occurred after Ms. D'Angelo left, is further evidence of the culture within the department.
But how
So
does the
am I-
culture bear on the timing? Again, we need to find an anchoring event for the rest of this material to become relevant.
I do believe that the constructive discharge is the primary anchoring event. And I do believe that the lower court erred because it should have been the purview of the jury to determine whether that was an anchoring event such that the other discriminatory conduct could come into question.
Well, constructive discharge, I understand, carries an element of coercion by the employer. In this instance, however, the constructive discharge results in the decision of the employee to terminate her employment based on activities by the employer, all of which, again, from what we have in this record, preceded the relevant date.
I do disagree with Your Honor in terms of that there are no events between that date in July and
I know you do, and what I'm asking you to do is, other than the constructive discharge, it would be very helpful if you could identify where in the record we have evidence of what those acts were.
We have the testimony of Ms. D'Angelo again, and I hate to repeat myself, but we have the testimony of Ms. D'Angelo about her seeking medical treatment and the case law that I cited that
Her seeking medical treatment is not an act of the employer. It is an effect of the prior actions by the employer or the other employees.
I would argue to the court that it doesn't necessarily have to be the prior acts, but it could be the contemporary acts and the ongoing nature of the discrimination.
That would be great. Now, if you can simply point us to the evidence of the ongoing acts, that would be very helpful.
So if I hear you correctly, you say the union vote and that he campaigned against her receiving the Sousa report, right?
Yes, and I also
In the 300 days. Do you have anything else?
I do believe that the repeated refusal to provide the Sousa report under the Meehan case also is an act of discrimination by the town.
Is the denial of union representation an act of discrimination? And if so, are these the right defendants on that claim?
That's a great question. I do not believe that these would be the proper, to be quite honest, I don't think that these would be the proper defendants, but to the extent that the main perpetrator of the discrimination, Mr. Bayer, is the president of the union, I think that one could reasonably conclude that there was some sort of impetus there and influence by him as to what kind of
But he's sued in
support.
his individual capacity, right?
I'm sorry?
He's been sued in his individual capacity.
Mr. Bayer has, yes.
Why is the MOA not, let me rephrase that. Do you agree that the memorandum of agreement relating to the grievances constitutes waiver of any of the issues?
No, Your Honor. Ms. D'Angelo has advanced the argument, first off, that she believes that a jury could find that it was a result of coercion. Putting that to the side, which is a very factual, fact-based analysis that the lower court never went into. The MOA was very specific as to only releasing the town. So Takasian and Bayer were not parties to the agreement. It also related only as to that one internal affairs investigation that resulted in her discipline. It doesn't.
The chief isn't the town for that purpose?
No, he's been sued in his individual capacity, Your Honor.
I didn't see a definition of releasees in the memorandum of agreement. Do you see a definition of releasees?
I don't, but I believe that that's the failure of the town. They should have been specific if they wanted to include Takasian as an individual releasee and not, the contract four corners right there says the town. That's not ambiguous in so far as my understanding of it.
So the chief argues that Lieutenant Danziger did not need to interview DeAngelo about the two reports that became that were behind the MOU because her reports provided sufficient description, and apparently none of the male police officers' reports provided sufficient description. What do you say to that?
I find that very hard to believe. I mean, you have multiple instances of IAs where the men are always interviewed, and they didn't provide Ms. DeAngelo that very basic right to have to discuss with Ms. Danziger exactly what happened and why she did what she did.
Okay, but that non-interview was outside the 300 days?
Yes.
Were there any instances of interviews or non-interviews of the male police officers within the 300 days?
I don't believe that's in the record, Your Honor.
All right. I see that your time has come to its end. We will hear from counsel for the appellees, who are, as I understand things, dividing their time.
Yes, Your Honor. Thank you very much, Your Honors. May it please the court, Alexandra Gill on behalf of the defendant appellees, former Chief of Police of the Town of Truro Police Department, Kyle Takasian, and the Town of Truro. I'd like to start with the statute of limitations issue, which was the basis for the lower court's ruling in favor of the defendants at summary judgment. When an employer takes an adverse employment action, the Chapter 151B limitations period begins to run at day 301. No matter how meritorious the plaintiff's claims are, she can no longer recover absent specific circumstances that trigger the application of an equitable tolling doctrine. And equitable tolling is to be used sparingly, and the circumstances are exceedingly limited. Under the Cuttier standard, a plaintiff must show the existence of an anchoring act or continuing violation that includes conduct occurring within that statutory period. The anchoring act must.
So here she says, right, so let's just cut to it. So here she says, refusing to put this document in her personnel file or give it to her is an anchoring act. Why is she wrong?
Your Honor, the town's refusal was based on the assertion that it was not a personnel record. It has no substantial relationship to her claims of earlier harassment.
It completely exonerates her from what must have been an incredibly stressful situation. I mean, you describe it as potentially career-ending.
I disagree, Your Honor, respectfully, that the Sousa report exonerates her.
All right, well, let me pause you there. Do we use a subjective standard from the employer's point of view, or do we use an objective standard to determine whether a document should be in the personnel file?
It would be an objective standard, and this document was not requested by the town. It is essentially an unsolicited letter by a third-party independent contractor who was hired to provide remedial training.
So who do we trust on that it was not solicited by the town? And before you answer that question, let me say that as I think a taxpayer might say, are you kidding me? You've engaged someone to train her for 2 days to correct such terrible behavior that you say it was potentially career ending, and then you don't ask for a report as to how the training went? That seems, from a taxpayer's perspective, that I'll be understated here, would raise an eyebrow. But you say it was unsolicited. We're on a motion to dismiss. Is there any evidence of that?
Well, there is evidence that in Chief Takajian's letter in retaining former Police Chief Souza, he did not request any report, and that the report came to Chief Takajian and he didn't expect it, nor did he consider it with respect to any employment action related to DeAngelo. It was a gratuitous letter that Souza took it upon himself to create and opine about the circumstances, even though he didn't have all the information. He admits he didn't have the town of Truro policies related to strip searches at the time. He admits he didn't have any report by the police. He also acknowledges that he wasn't aware of the circumstances under which that report, that incident came to everyone's attention. And that is the basis of Ms. DeAngelo's claims, that but for the harassment of her subordinate, these arrests would not have been flagged for the town to address.
Right, and he's an outside third party who seems to think she's right about that. And the town didn't want her to see that report, apparently.
It's not that the town didn't want her to see that report. The town did not feel that she was entitled to it as a matter of law. It was not a personal record, and the town wasn't obligated to provide it. I think there's a distinction there, and you're correct. A taxpayer might say, well, why wouldn't, if you send a police officer for remedial training, why wouldn't you request a report? But there's no requirement that a report is requested, and I think reasonable minds can disagree or can differ on whether or not that circumstance of remedial training merits the creation of a report.
But hypothetically, if she had gone for this 2-day training and Souza thought, man, she's terrible, she's putting the people of Truro at risk, you got to get rid of her, I'm guessing the chief would want that report.
I do not believe that the record evidence suggests that Chief Takajian or the town of Truro would have produced the report in those circumstances either, Your Honor. I think that the town and the record shows that nobody viewed this as any kind of reliable input on the events. And by that point—
So why send her?
I'm sorry?
Why send her if you were sending her to an unreliable retraining?
It was not that the training was unreliable. Former Police Chief Souza was very capable of providing the training. It's that the report and the basis for his statements in the report, which he acknowledges at one point is, quote, pure conjecture, unquote, no reliability there. And even if it had confirmed everything, neither the town nor Chief Takajian would have viewed it as something that had any impact, because by then the memorandum of agreement had been signed. Ms. DeAngelo signed it knowingly, fully, voluntarily. I think there are 7 instances in that short memorandum of agreement in which she acknowledges being given time to consider it, having had the assistance.
The memorandum of understanding in her personnel file.
I believe it was.
Okay. If the town, if someone were to conclude that the town that this should have been in her personnel file, the Souza document, and they're required to give it to her and did not, could there be liability against the town?
My understanding of the correspondence with the records access officer was that it was unclear what the town's rationale was initially in withholding the report, and the town was directed to provide a response to that request, which was request number 1. And in response, the town did provide the report. So
was that before she filed suit or after she filed suit?
That was before.
How will we know that? Is there a record citation?
Her suit was filed in I'm forgetting exactly what I think she filed on. She was disciplined in March 2016, and I believe the correspondence goes from late 2016 to early 2017. I don't have that exact date of the correspondence between Attorney Jenkins and the state.
So in this chapter 149, section 52C, the definition of personnel records includes, quote, employee evaluation documents. The Souza was hired as a trainer by the town. How is his report not an employee evaluation document? Because it seems to evaluate her conduct.
Souza was hired as a trainer. He was not hired as an evaluator. He was not asked to evaluate. There were not prescribed standards for him to create an evaluation of Ms. DeAngelo's conduct. He was simply hired.
What do you think? He goes through whether her conduct was in accordance with good police training, or whether she might have failed in any particular instance or needed any kind of correction. How is that not an evaluation?
I think by that logic, Your Honor, any person, any civilian could make a statement about somebody's police conduct, and then that would require the document to be put in that personnel file.
That's not a civilian is not a trainer, engaged by the town, who's arguably an expert in police conduct. I'm guessing I'm hoping the town wouldn't engage somebody who was not an expert in police conduct to do a retraining.
No, but I also would hope that the town would not engage somebody to evaluate somebody without any prescribed standards, or without providing them with the necessary information in order to make an assessment of that person's conduct that they were hired to give corrective training to. And the record shows she really needed it. There were people who were subjected to strip searches. There were two individuals subjected to a breathalyzer test when only one of them was driving. And, I think
the other one had been driving, and she saw him herself. She personally saw him driving. And there's certainly an argument that Souza report says repeatedly on a number of places that her training, that what she did was fine. There's one place, I think, where it says that she could have done better, which was that she'd been working a double shift and she was exhausted, I think, and didn't give the citations right then.
Right, and she instructed a junior officer to lie to the arrestee and tell them that the circumstances of receiving their citation were not what they actually were. So, but I will say that the plaintiff suggests that Chief Takajian should have just let it roll and let those criminal complaints sit and hopefully be caught by the justice system down the road. And that is not the kind of integrity that we want our police departments to operate with. I think it was.
Miguel, I think we'll have to leave it there. Your time has expired. We'll hear from Attorney Clark. Thank you.
Thank you, Your Honor. May it please the court, John Clardy on behalf of Craig Baer. We agree with the trial court below that there was properly no evidence of any discrimination within the statute of limitation periods, especially as it pertains to Craig Baer, a subordinate employee who only overlapped in his employment with his sergeant for some 21 months. A subordinate employee notably cannot discipline.
He was union president, right?
That's correct. During the entire time of his 2-year tenure there, but at relevant periods.
What do we make of the union's denial of representation for Ms. DeAngelo?
It's astounding to me that that's even considered evidence here of sexual discrimination or sexual orientation discrimination, because it had absolutely nothing to do with her gender or her orientation. It was a vote of the entire member of the union. There was 9 votes, as far as in the record, against hiring an attorney for her. So it was a vote as to whether the union should pay for her attorney to pursue the Souza report, is my understanding. And 9 other members, not just Officer Baer, voted against. So, and there's no evidence that vote was in any way based on her gender or her sexual orientation. So I just don't see how it can possibly be linked to a discrimination cause of action. It was a union vote.
So I think her response would be, okay, these. It seems like it's all men. She would say these men were smart, right? And they didn't use crass comments, but that they, in fact, were still that they were still discriminating against her. Like that, is it possible that employees that could possibly at some point be in her shoes wouldn't want the policy to be that you get this report, and that's an issue for the jury? So what's your response to that? Why is she wrong?
Well, twofold. One, he's just one of 9 members that voted against it. So if there were any animus of these other members, potentially, certainly that he wouldn't be vicariously liable for their hidden animus. I think there's absolutely no direct evidence of any anti-gender or anti-sexual orientation animus by Officer Bayer. So it's just essentially she's trying to suggest that this is somehow circumstantial evidence, indirect evidence. It has to be tied in, though. Just because there's an adverse action doesn't mean. So that's where she's arguing differential treatment. Well, where's the comparator for others who have sought to get personnel records and getting union representation through, her union, her attorneys paid for seeking personnel records? There are none. Okay, this was a vote of the union as a whole, for which my client, Officer Bayer, should not be held liable, nor is there any evidence that there was any hidden animus in there, nor should it be. This is actually, think about the rights of the union members to vote as their conscience sees fit, right? So now we're going to hold union members liable for how they vote, and a union vote is somehow creating
I think there's precedent for doing that, but turning to this issue of the definition of releasees in the memorandum of understanding, can you show me a definition of releasees in that document?
No, Your Honor, and I agree there isn't one within the 4 corners of the document, but certainly the subject matter of the release was the reporting as to the Rand incident. So if she can't bring an action rising, she's waiving any claims arising from that subject matter. Certainly she can't use the subject matter to go after her co-employees or her subordinate employees.
Can't she use any events that comes out of that, or the event itself, to say, well, they in fact did discriminate against me because now I have the Sousa report that, basically one could argue exonerates her.
So I think, Your Honor, that goes to the scope of the release as opposed to its who's covered by the release. And I think I would agree with the court that if there was conduct outside of the Rand incident, it wouldn't be covered by that release. But I think the Rand incident itself, which would entail the reporting by my client, Officer Bayer, would be released. And that's essentially one of the main things that she's arguing was his culpability. We would point to his obligation to report that. And again, he's a subordinate employee. He was obliged to report what he perceived as misconduct. And going back to the evidence, where's the evidence that there was any anti-gender or anti-sexual orientation bias in his reporting, something that he was obliged to report?
I think the issue is she came on late 3 hours after some guy made the initial decisions about how to handle Mr. Rand, and that, if anybody was going to get reported, it needed to be both of them. But since it was just her and not him, and I think there was some other man who also could have been reported but wasn't, she said that's evidence of discrimination right there.
Well, she's the only one that told the subordinate to lie about it, to backdate the report and to lie to the arrestees.
But that wasn't fully the basis for it. There was identical conduct between a man and a woman, and the man wasn't disciplined.
I would suggest the record would reflect that the untruthfulness is actually the genesis of the reporting by Bayer. I see my time is up, and we'll rest on our papers unless there's any further questions.
I see no further questions. Thank you all for your argument. The case is submitted. And we will now resume this session in the Hale courtroom. This Zoom hearing has come to a conclusion. Thank you.
Thank you very much.
Your honors. Thank you, Mr.
Thank you,
Clerk.
Honor.